Good morning, everyone. We are so thrilled to have everyone attending today. Welcome to our webinar, Navigating the Psychedelic Patent Landscape, Inclusive Strategies for Innovation and Protection. We're thrilled to have you here. My name is Juliet Meccia, and I'm going to be your host today, along with my colleague, Jeremy Rolquin, and both of us are data and patent analysts at Porta Sophia. Porta Sophia, the host of the webinar, is a nonprofit dedicated to protecting the public domain. Today's goal is to provide you with an overview of the patent landscape for psychedelic intellectual property, equipping you with necessary tools and insights. We're excited to introduce our diverse panel of experts, and each panelist will provide more context on their expertise at the beginning of their talks, but I'm going to give you a brief introduction now. So Kimberly Chew will provide an overview of the psychedelic industry and regulatory outlooks. Pechenik will discuss intellectual property and the essentials of the patenting process. Simeon Schnapper will share insights from the perspective of investors and venture capitalists. Jeremy and I will share strategies to understand threatening psychedelic patents and how to take action to protect research and development. And Maria Islas, a distinguished Indigenous healer and educator, will share her insights on traditional medicine, ancestral sciences, and bridging ancient wisdom with modernity. Her perspectives will help us consider and respect Indigenous viewpoints in patenting psychedelic therapies and fostering a more ethical and inclusive patent landscape. We are excited to bring attention to Porta Sophia's Indigenous Awareness Initiative. So Indigenous communities have used psychedelic plant and fungi medicines for millennia, yet their contributions are often overlooked. Our initiative strives to respect and protect Indigenous practices and knowledge when evaluating patents. Unfortunately, we don't have time for a Q&A session today during this webinar, but please feel free to put any questions that you have in the chat, and someone from the Porta Sophia team will monitor and respond or forward your questions to the panelists. Now, to start our discussion, Maria Islas will share her wisdom on traditional and contemporary medicine. So Maria, please go ahead. Thank you.
Thank you. Mishpancinco. Nani monotza Maria Islas. Nani ewa Mexico Aztepet. Tlen pakilistli totechmochiwa. Nechpaktia y wan nechyolewa. Ma anmewan anmotekipachoa. Ipampa tutlakawi. Intlento ach totawan. Otechmomahkilike. Senka mawistik. What a joy is made in me. It lifts my heart that you care about for what our first parents left us and put in our hands. It is our legacy, and it's very honorable that we can sit together to talk and to share our experiences in the present moment. I thank with great joy for the invitation. I believe that to dialogue and to think together is what will enable us to open promising pathways for our world, our planet, our humanity. I want to start with one main idea from Mexican traditional culture. And it says that every human being already has the dose of medicine he or she needs. This dose is defined by the size of the palm of his or her hand. And the elders of traditions knew this very well. In our hands, we have the possibility of measuring what we need to receive, what we need to give. So this will be the main idea that will accompany all of the reflections I prepare to share with you today. As never before in the history of humanity, we are living very complex times. We are in a moment of great global expectations, but with uncertain perspectives in the face of unforeseen futures. How did we get here? Are humans about to find ourselves in checkmate? In relation to the future, These are almost unanswerable questions. So, in moments where imagination is necessary, we also begin to awaken our memory. Memory supports us in the recognition of life as a continuity, constantly reinventing itself. So that's why I begin by acknowledging and thanking the life of all the human beings who observed, understood, translated, expressed, and preserved the knowledge that today brings us together. The arts and sciences of human life on planet Earth. The culture to which I belong is called Anahuacan culture, a civilization that used to live in the territories that goes from Alaska, Ashkan Anahuac, to Nicaragua, Nican Anahuac. The name Anahuac can be translated as the important territory that is surrounded by water, very destructive. So the Anahuacan culture is a mother culture, like the civilizations of Egypt, Mesopotamia, India, to name a few. Like any other mother culture, it was able to incorporate knowledge from other cultures without losing its original foundations, to continue with its evolutionary processes, waiting to be reborn when the time needed it. Like what is happening today, we are witnessing the rebirth of ancient knowledge. Life is a continuity. Ancestral cultures can be forgotten, erased from history, but those that survive are never outdated. They are translated into new applications of everyday life. They adapt to a contemporary language, mainly because cultures are living organisms that adapt and evolve. On August 13, 1521, everything that was science in ancient Mexico began to be incorporated into the imposing culture of the Castilians. And the science became tradition, custom, or even worse, folklore. Untold thousands of teachings painted on deer and jaguar paper skins were burnt. And with them, the gritted memory of a civilization that went up into smoke. Since the modern science perspective considers that only that which is written passes for veracity, my culture lost its scientific character, and it became an object of cultural interest. Moreover, with the invention of the science of anthropology, the scholars and experts began to rewrite the story of Mexico based on texts written by foreign friars who saw religiosity and sacrifice everywhere. Psychospiritual practices that included mushrooms, that we now call psychoactive, were demonized and reported as diabolical rituals. Interestingly enough, the original name of these mushrooms, Teonanacat, was translated to Spanish as the flesh of God. But actually, a more accurate translation for Teonanacat would be the knowledge that arises from an embodied life, the supreme knowledge that we can achieve when we are embodied as human beings. Let's remember that these mushrooms are basically water that took shape, the same as human beings. We are just water that has taken shape into this human form. So to this day, we worship the indigenous cultures presented in museums, while we continue to plunder and erase their identity. We simply call the group of people who are heirs to a great diversity of identities and knowledge that in fact interest us today, indigenous. Going back to my story of my culture in Mexico, in order to preserve the scientific knowledge developed in ancient Mexico, the great mothers and great fathers of traditions divided their sciences into 4 large areas, identifying them by colors and geographical locations. In the east, white. In the west, red. In the south, blue. And in the north, black. By using different colors and geographical locations, paradoxically, the science remained united because they are the synergy of the whole that generates knowledge. Each of these sciences oversaw safeguarding the most valuable pieces of a violated and mutilated civilization. Why is it important to talk about this in a panel like today's? I think we need to recognize that what we call today the so-called indigenous world comes from fragments that managed to survive because they were translated into metaphorical and foreign languages. The sciences that studied the electromagnetic vibration of everything that exists were called the feather serpent. The sciences that studied the behavior of winds and meteorological phenomena were called the god of rain. The sciences that studied the processes of photosynthesis performed by the plant world were called the god of flowers. The study of the mind and the awakening of the deep senses of the human being is called shamanism. The studies of the astronomical observation and the measurement of the effect that astral movements have of human beings are called rituals. The arts and sciences of transforming human consciousness through intuitive communication with the life around us, transcending conventional time and space, deeply rooted in communitarian beliefs, is called psychedelic practice. Ancestrality will always serve to clarify the understandings of life, to inspire a new perspective, to expand our personal universe. But what prevents a person from transcending his or her personal universe? What prevents an individual from accessing his or her innermost self in an harmonious and pleasurable way? One answer: the ignorance about our vibrant, woven, and changing nature. How many wars? So many embassies are being closed. That means no more peaceful dialogues with good intentions at all. The whole that we form integrally. Diplomacy, like good education, is being abandoned little by little. Let's remind the banality of evil by Hannah Arendt. Let's be realistic. Something deep in our mentalities will have to urgently be transformed. In fact, it is urgent that we nurture a healthier integrated evolution of intelligence, and a willingness to understand oneself and others. This begins by assuming an attitude of respect for all that is natural in this planetary dimension. A change of mentality for the evolution of the social culture, for the evolution of the movement of intercultural perspective. At the foundation of all philosophies, the same points coincide, the same questions about existence. For example, according to Mexican tradition and culture, human beings have 5 senses: the vision of the eagle, the hearing of the jaguar, the smell of a deer, the taste of a rabbit, the touch of the snake. Beyond them, we have the capacity to develop other 3 senses of perception and action: the precious intelligence of the quetzal, the willpower of the hummingbird, and the weaving memory of the spider. Memory allows to recognize that we are part of the same continuity, and that in the search for the evolution of consciousness, the paths belong to everyone. The healers, those who first gave these medicines we're talking about today, neither call themselves healers, nor they charge money for their work. The healer was a healer because he had received a gift, usually through an illness that instructed him or her. Therefore, to restore harmony and balance to the individual and the community, he or she oversaw giving the service of opening the way for those in need. Ancestral sciences of medicine are, by nature, inclusive, not exclusive. Well, now more directly on what touches our subject. Talking about patenting the use of a substance used for millennia, it's not only a matter of cultural appropriation, but also of dismembering into parts an ancestral health system that first and foremost is communitarian. A health system that not only attends to emotional or mental processes, but also social dimensions and intercommunications with the subtle aspects of what exists. It is about the possible loss of the whole of the alchemical elements, important to obtain a static transmutation, not only a partial person state of well-being. There is an energetic, spiritual context interconnected with the soul side of matter in several dimensions. For there to be a quantum leap in life change, be it with mushrooms, psilocybin, or not, the doses must be interrelated in parallel with the education of the human being in a more panoramic vision, more expanded, both vertically and horizontally. It is almost 29 years since the night of June 29, when Maria Sabina presented the velada for Wasson. She went through all the steps of the ritual. However, what became known in Western culture was the isolation of a chemical compound, and today, the possibility of its exclusive use. The millenary science of dialoguing with the little ones that bring forth Nindotosho. It is in danger of being reduced to the commercialization of a chemical compound. The psychospiritual mastery to diagnose, dose, and accompany the vigil, the velada, now begins to be transferred to medical Western contexts under scientific experimentation, erasing the millenary tradition that already experimented scientifically and that still survives as an invaluable source of advice and collaboration. Our elders are finally leaving. An era is ending. We have the last chance and opportunity to co-create new models of ancestral intercultural medicine for the future. The times have changed. It is counterproductive to insist on the same mistake, even more for centuries in a row. In the error of believing that the solution or the evolution will come from the perpetuation of the painkiller culture. In the meantime, my suggestion is to open the dialogue as today with elders to include the understandings of the processes of opening of consciousness, of the tradition of rituals, the necessary ecological and environmental practices, and the effects of mushrooms in the spiritual collective psyche. As I said in the beginning, every human being has already the dose of medicine that she or she needs. This dose is defined by the size of the palm of his or her hand. And the elders of tradition know this very well. And now we know this. So if we want to make business, let's include the elders, of course. So we have balance and communication, dialogues between all dimensions, all the times. And we will create a more rounded and human world. Thank you for your attention.
Thank you so much, Maria. Next, we're going to hear from Kimberly.
Hi, good morning, everyone. Let me just go ahead and share my screen. Hopefully this will work. Does everyone see my PowerPoint, I hope? Okay, I'm going to, good morning. My name is Kimberly Chew. I am a senior counsel and co-leader and one of the co-founders of the Psychedelic Therapeutics and Emerging Therapies Practice Group at Hush Blackwell. We just heard from Maria Islas, and it's my honor to participate as a part of this panel, just to give you a few aspects of intellectual property law as they apply to psychedelics. So my portion will be discussing briefly just trademark considerations, trade secret, and regulatory exclusivities. Just to give you a brief overview of my presentation is I will talk about the market potential as been estimated by several sources of the psychedelic industry, ethical considerations, and touching just a couple of points that Maria mentioned, as well as trademark laws, exclusivities that are available through clinical trial development, and possibly, if we have time, mention botanical products, as some of them might be considered biologics and might be subject to those levels of exclusivities. So with that, in terms of market potential, the current market size, these are just a few of the current market size estimates for psychedelic products. As you see from these headlines, they vary from 6.4 billion by 2034, all the way to 12 billion by 2035 by various research organizations. And we can thank this the significant rise in mental health disorders in the world, and as well as the progressive acceptance of psychedelic drugs for therapeutic applications.
Kimberly, sorry,
yes.
We're not seeing the PowerPoint sharing. Would you
Oh,
mind
you're
sharing
not?
that again? Yeah.
Oh, I'm so sorry. Why is that? Oh, maybe I didn't hit share. So sorry. Okay, let me go back. I'm gonna hit share, and then hopefully this will show up. Okay, Is it sharing?
Yes, it works
Okay,
now.
I'm
Thank you,
so
Kimberly.
sorry. Okay, so this is the very beginning of my PowerPoint. At any rate, just to reiterate, this is just some estimates for the large size of the psychedelic market as estimated by several sources. We can probably think these are pretty large numbers. And it's probably due to the significant rise of mental health disorders, as well as progressive acceptance of psychedelic drugs that we've seen over time. In terms of clinical trials, at least, and acceptance of, for a long time, psychedelics weren't even allowed to be trialed. So we're seeing that being growing, and that's probably contributing to this escalation of market growth. So in terms of developing psychedelic therapeutics, it's important to consider the ethical aspects of commercializing natural and indigenous resources. This includes sustainability and cultural respect, such as sustainable harvesting and compensating for indigenous intellectual property. Ethical development also involves informed consent and upholding the dignity of cultural practices. So in the realm of developing psychedelic therapeutics, these ethical considerations take on a unique significance because we're engaging with natural substances, depending on which psychedelic you're talking about, right? So you're engaging with natural substances that are also part of indigenous knowledge systems. So for those entrepreneurs that are hoping to develop those kind of resources, those indigenous knowledge systems should be considered in your development of your product, and not perhaps not solely investor money. So it's important to acknowledge that these therapeutic ventures acknowledge the sacred and cultural dimensions of these psychedelic substances as they've been traditionally used and guarded by indigenous populations. So I'm going to launch into I'm just going to be covering a few intellectual property topics as they apply to psychedelics on a high level. So trademarks are a type of intellectual property that denote a distinctive sign, design, or expression which identifies products or services as emanating from a particular source. So it distinguishes them from others in the marketplace. We see them all the time in the Western world. So as the psychedelic industry grows with this increasing recognition of the medicinal value of psychedelics, establishing strong trademarks becomes vital. So it enables companies to protect their brand and assures consumers about the quality and origin of their products, if you have a strong enough brand, that is to say, and facilitates the safe and regulated growth of the market. So for an industry working with substances that have historically been part of communal traditions, trademarks also carry ethical implications. So they should be developed. They should really be considered developed with sensitivity to cultural heritage of indigenous communities that have long used these substances. Again, depending on which psychedelic substance you're talking about, for spiritual healing and healing purposes. And so thereby ensuring that the commercialization of these therapeutics preserves and respects traditional knowledge and practices. So in terms of continuing the theme of trademarks in psychedelics, the intersection of trademark law with controlled substances, including psychedelic compounds, presents a unique legal landscape. So trademark laws generally prohibit the registration of any mark associated with illegal activity. However, as policy changes and certain psychedelics gain legal status for therapeutic use, the situation evolves, and it's evolving. So this legal shift opens pathways for companies in the psychedelic sector to protect their brands through trademarks, provided that they navigate these complexities conscientiously. For instance, a product that contains a controlled substance but's approved for medicinal use might be eligible for trademark protection because, since they have a recognized medicinal use, they're now legal. So visual elements of trademarks in psychedelics, such as logos or packaging, are not the only marketers of identity, but also contribute to the industry's destigmatization efforts. Sorry, I can't always mess up that term. So some of the challenges in trademarking, as I alluded to in my prior slides, involve the primary hurdle, it being that if it's going to be traded between states, it's going to have to be legal activity. So that trademark actually cannot denote an illegal activity. So the primary hurdle for federal classification of your trademark, and there's different levels. There's federal trademarking as well as state trademarking. The primary hurdle for federal classification of your mark for psychedelics is that it's illegal. So that is, a company seeking to trademark a brand that's related to psilocybin may encounter obstacles because psilocybin is on the federal Schedule I status under the Controlled Substances Act. So additionally, even in jurisdictions where some psychedelics are decriminalized, there still may be a variance in the trademark acceptance. So we're seeing emerging a patchwork of trademark protections that are going to be lacking uniformity across the nation. So one of these a hypothetical scenario that can kind of highlights this challenge could involve a business that operates legally under a state's laws where certain psychedelics are permitted, for instance, Oregon, but also they cannot secure a federal trademark because it's not allowed under federal law for that is to use psilocybin on a federal level. So these precedents are still being set. I mean, it's still a fledgling industry, and companies have to carefully navigate these uncharted waters for public perception as well. So, and just being aware, any entrepreneur or innovators in the space should be aware of these varying local laws and potential ethical considerations regarding appropriation of Indigenous knowledge and cultural symbolism. So as the industry matures, it's expected that trademark strategies will become increasingly sophisticated to address these multifaceted legal and cultural landscapes. So one of the things that I was alluding to earlier is I put this slide in because this area might be really fraught with being insensitive, potentially insensitive to indigenous use. And these are just some tips really to think through for entrepreneurs, innovators to think through about their trademarks. If they're, considering whether they're doing appropriation of a sacred symbol or name or practice. So you should, focus on original branding and consider collaborating with indigenous communities and educate others on cultural significance of your product, as well as maybe your whatever therapeutic you're engaging with, and consider supporting indigenous causes, and consider obtaining consent before using a particular mark. And I can see that I am running a little low on time, so I'm going to kind of speed through these next couple of slides. In the interest of time, I think we can make these slides available later for others to read through. The other aspect I wanted to discuss briefly was trademarks, trade secrets. Trade secrets are a form of intellectual property. There are things like formulas, things like Coke's secret formula, which was protected as a trade secret. There is no timeline, unlike patents. Patents have a 20, Graham's going to be covering that, but like a 20-year horizon of protection. Trade secrets, if you protect this aspect of your product as a trade secret, it can last forever. So you will have to put in practices into your company to maintain it as a secret. And so I won't go into that right now since kind of cutting close on time. This slide goes into a little bit what I alluded to previously about there's strategic considerations as to whether something, an idea of yours should be patented or should be considered a trade secret, because it may be great that you have trade secret protection forever if it's protected as a secret. However, things like regulatory, if you have a drug, a therapeutic that you're trying to get through the FDA, there's a lot that you're going to have to disclose in order for the agency to evaluate its safety and efficacy. So, and in that case, a trade secret for certain aspects of that will not be feasible. So I was going to talk about clinical, trial exclusivities under the regulatory schemes. I'm going to kind of breeze through this. So new chemical entity exclusivity, which is under the Hatch-Waxman amendments of 1984, gives you 5 years of exclusivity under the FDA. So it limits generic competition. These FDA, and that is the regulatory exclusivities, run in parallel with patent exclusivities. Another one that innovators could go for is orphan drug exclusivity, which is available if you're treating a rare disease that affects fewer than 200,000 people in the United States. And then you can get 7 years of market protection under the FDA. And this pediatric exclusivity is a little bit more recent. It was enacted under the Best Pharmaceuticals Act for Best Pharmaceuticals for Children Act of 2002. It's pretty valuable, actually. It does when you initially look at it and says, oh, it grants 6 months of market protection. What does that mean? It actually tacks on 6 months to what you already have. So it can tack on 6 months of preventing a generic entering the space after the actual term of a patent, for instance, or your NCE exclusivity. So it tacks on the end, and because it tacks on the end, that's when apparently it's the drug is usually, or the therapy is usually most profitable. And so the Congress had enacted this in order to ensure vital information. A lot of these drugs are being prescribed for children. And so in order to get them into the clinical trial, to understand what risk children are facing and where they can be closely monitored in a clinical trial, that's what this is meant to encourage people, sponsors to get. So biologic exclusivity, I included this. It is a long exclusivity of 12 years that a innovator can prevent generic from entering the market space. It's significant, and it is, I included it because there are some botanicals, and then there might be some other biologics, that is therapeutics or drugs that are considered biologics. These are very, complex type of therapeutics. So if the agency considers it a biologic and then you pass agency approval, you can be granted 12 years of market exclusivity that runs in parallel to your patent, any kind of patent application that you may have out there, and it's pretty valuable. There's also new clinical investigation exclusivity under 21 CFR section 314.108. It's granted for 3 years if a drug contains a previously approved active ingredient, that is, it's out there already, but then you as a sponsor find a new application and are running new clinical trials, and so they will afford you, the law affords you 3 years of regulatory exclusivity in that case. And I'm going to this is my final slide, and I'm only mentioning this that a lot of botanical drugs are regulated differently, and there's a whole botanical drug development guidance under the FDA that if your drug follows that, then great. But it also something to consider is that it might be classified as a biologic. And so I had just put some of the factors as to when a regulatory agency might be considering your botanical as a biologic, and then you might be afforded the 12 years of biologic exclusivity. And I appreciate everyone's. Let's see if I can get this back to not sharing. Okay, everyone, here we go. Stop sharing. That is the end of my presentation. I appreciate everyone's attention.
Thank you so much, Kimberly. Next, we'll be hearing from Graham.
Thanks, Jeremy. And thank you, Kimberly, for that last presentation. And Maria for a really beautiful opening. I'm going to try to share my screen now. So I'm going to use my 15 minutes to talk a little bit more about patents. 15 minutes is not a lot of time for what I'm hoping to cover, which is what patents are themselves, what patents have been filed in the psychedelic space, a little bit about what patent examination looks like, and patent policy issues, some of which that come up in examination, and some looking at the patent system and the types of patents we have in the psychedelic space generally. So I'll be a little zippy. Like Kimberly said, I'll share my slides after 2. Just the kind of briefest background of why I'm even here talking to you today. I've been interested in psychedelics since my first psychedelic experiences in college. Actually thought I'd be a psychedelic chemist, but went to law school. I didn't receive much encouragement for that. Because of my science background, I did patent law primarily for branded pharma, started the firm I have now, Calyx, a lot of work really in the cannabis space. And then in 2018, this article came out, which kind of made me first realize there was going to be a wave of patents in the psychedelic space, similar to there was in cannabis. This was the first article that mentioned that Compass had filed a patent on psilocybin. This was still about a year before the actual patent itself had published, and had this quote in it that said that this sort of patent is not unusual in the pharmaceutical sphere, but it's new to psychedelics. Having worked about a decade in the pharmaceutical sphere, of course, I knew about pharmaceutical patents, but I hadn't really seen any about psychedelics, so I was curious and looked them up. This was November 2018, and there was just over a dozen patents published on psilocybin, many of them early ones from Albert Hoffman, and a lot from Paul Stamets, who people might know. And even 2 years later, so I kept this list going. By 2 years later, I'd actually started putting this table on what's now psychedelic alpha, what was then psilocybin alpha. There are still even under 24 patents on psilocybin now, and I imagine people are relatively familiar if you've been here, because it's been a little bit of a while that we've been talking about psychedelic patents, but there's over 1,750 published psychedelic apps, applications and patents. And depending on how one counts, maybe one finds a few more. I try to be a little bit under-inclusive. There's a lot of patents on drug testing and things that may include psychedelics in the just specification somewhere as a word, but these are really ones that focus on psychedelics that could be granted on the use of a psychedelic, making a psychedelic, novel psychedelic. So there's quite a lot. And every time I make this slide, I have to update this number. Even so, because patents don't publish or applications don't publish for 18 months, we don't know what will be, what has happened in the last 18 months. The sort of wave of investment has probably passed to some extent. So a lot of the patents that are published now are ones that were at the real peak of the kind of psychedelic hype cycle around 2021. But we still probably have a lot more patents on psychedelics to see. And of course, this reflects the growth in companies from 2020 to today. Now there's many companies, and question mark there, because there's probably many still in stealth that many of us may not, I don't know about. And kind of contemporaneous with all of this increase in patenting has been a lot of controversies around patenting. Many people probably are familiar with many of these articles or have seen many of them. This is just the ones I could get on a slide and still be able to sort of read them. So there's many more outside of even these. The controversies around patents, I think, kind of like hit the biggest mainstream by even being discussed by John Oliver on Last Week Tonight. So I think most people at this point, probably, and especially people in the audience, are familiar with a lot of the controversies around psychedelic patents. And psychedelic patents became controversial enough that two respected law professors actually wrote that potentially, although they called it a radical step, a very radical step, potentially there shouldn't be patents at all on psychedelics because they're of such importance to science and public health. Well, why do we have patents on psychedelics, or why do we have patents on psychedelics thinking about them as compounds to be brought through the medicalization route, at least, which is sort of the focus, at least, of my presentation, and certainly the focus of a lot of why the patents have been filed on psychedelics. And that's because developing new drugs costs a lot of money, but it doesn't cost very much to bring a generic to market. That's because all the research that goes to proving that a drug is safe and effective at the FDA, all those clinical trials costs hundreds of millions, or as the industry sometimes says, over $2 billion, whereas to bring a generic to market, it's 1,000 times less than that. So of course, if one can copy the branded drug, the amount of profits that the branded drug can charge, because it doesn't cost very much to make a pill after it's been demonstrated to be safe and effective, the generic can copy that work and bring a drug that it sells for much less, were there no exclusivity. So of course, when exclusivity expires, the amount of sales of the branded drug fall pretty precipitously, and the amount of price, so the profits that one can make from selling the branded drug also falls. So of course, the reason, or the way that we keep the exclusivity on the branded long enough to recoup those that investment in bringing that drug to market is through, as Kimberly mentioned, there's a variety of different ways of regulatory exclusivities. So we know we get data exclusivity for bringing a new drug for the first time through FDA, and some other ones that Kimberly mentioned. And then, of course, patent exclusivities. So the primary one is the 20 years of exclusivity that one gets for a new claimed a new invention. And this can be adjusted a little bit depending on time spent in prosecution. Also for FDA, one can get extensions for time that's lost during the period of FDA review. And of course, these days or months or potentially years of exclusivity can be very valuable to the drug company because a blockbuster drug, so that's a drug making $1 billion a year in revenue, every day on the market is worth as much as a few million or maybe even more than a few $1 million. So of course, the name of the game here for exclusivity is patents. So what is a patent? So a patent is a right to exclude others from making, using, selling, offering to sell, importing the invention for a period of 20 years from filing. There can be some adjustments with that, but basically 20 years. And the invention is defined by the claims. So when we think of what a patent actually is, as a document, a physical document, it contains a specification, which is basically everything that tells you how to make and use the invention, all you need to know to practice the invention, what the invention actually is. And then the claims, which define specifically what the legal right to exclude somebody from doing with regard to that invention is. As some call them, the metes and bounds, or sort of the property lines of that invention. So this patent claim here is the one from that first Compass patent. The highlighted language here is kind of the crux of it, this crystalline psilocybin form polymorph A. And the reason we have patents, similar to, as I laid out for purposes of the investment needed to bring a new drug to market, the Constitution sets out what's called the Progress Clause, which says it's to promote the progress of science and useful arts by securing for limited time, so for this 20-year period, this exclusive right. And so this is often thought of as both a reward. So it's a reward for the outcome of that inventive activity and an inducement to do it, to invest in that activity that one might not otherwise, to bring forth this new knowledge. And so that particular reward or that investment is generally seen as providing this bargain or being considered as a bargain between the inventor and the public. So in exchange for the investment and the disclosure of the invention, one gets a temporary monopoly. And it's a balance because, of course, by providing the temporary monopoly, it keeps others from being able to practice it. But that invention might not even be known to the public if it weren't for the patent right at the as a reward for that activity. And so one thing I like to look at a lot, and sort of we'll try to frame some of the rest of what we talk about, is the fact that the patent should be seen as the creation of society. So this is from a Supreme Court case, calling it that because the balance is something that's set by legislative laws, by kind of rules of the Patent Office, by case law, and it's something that's constantly undergoing a change. How strong should that exclusive right be? How long should that exclusive right last? What inventions are worthy of being able to get the protection of that exclusive right? So this creation of society and what actually that patent right is, from a policy perspective, is something that is set sort of on an ongoing basis, and should be considered to be something that's continually up for kind of debate and negotiation. So the basic requirements for a patent, these 6 are generally considered the kind of primary requirements that one needs to pass to get a patent. The statutes are often what they're kind of called a shorthand. And I won't go through all this, just as I said, because I have somewhat limited time. The kind of main requirements, though, for a patent are that it has to be novel and non-obvious. Of course, it has to be something that's new over what's generally called the prior art. So the prior art, and I'm sure there's more from Porta Sophia in their talks, but the prior art is basically everything that was public or available to the public before the patent application was filed. And so the examination of a patent application is to look at each of these requirements and make sure they're all met. So it has to be something that's patentable from the perspective of being patentable subject matter. So it can't be abstract ideas. This doesn't really come up much in the psychedelic space, much more in software. It has to be described and enabled. So in exchange for disclosure, so putting everything in the patent application that eventually publishes, one gets this right. So the disclosure has to be sufficient. One can't get the patent by not telling enough to the public about how to make it. But really the rubber, again, hits the road here with the requirements of being novel and non-obvious. So it's sometimes seen as a negotiation between the examiner and the applicant, because often this is really during the examination process where everything happens. So the examiner searches for the prior art, assesses how the invention is different from that prior art, and then determines if that difference would have been obvious to somebody who's practicing that field. And then the applicant, when they receive what might be a rejection based on the examiner saying the difference is not non-obvious or is obvious, the applicant gets to distinguish the claims over the prior art. So they can say, well, it's not obvious because, or it's different because of these things, or it can amend the claims and narrow it around what that prior art is and say, well, what I'm asking for actually, this invention is a kind of narrower improvement over that. And so the first step, of course, in this is the examiner has to search for the prior art. So if we look at actually what happens in patent examination, and I'm sure we'll hear a lot more about this from Porta Sophia, but this is just one example that kind of shows how sometimes patent examination itself can be flawed. Here's a patent application that was filed. The red boxes around the filing date. So that's July 29th, 2020. So everything before that date is considered prior art, and that's what should be found and how the differences between that and the invention should be judged. And then what's claimed here is what that invention is. So a device for delivery of a substance with a chamber, a formulation, and a substance. But kind of all in short, this basically just covers a DMT vape pen. And so we know before that prior art date, here's 2 articles from August 2018 and one from 2020 before it was filed, very clearly setting out what a DMT vape pen is, and discussing what it is in a way that the examiner, if the examiner would have seen these, the examiner could have reviewed what the claimed invention is and whether or not that actually is obvious or not over this prior art. But what the examiner did was not search for DMT, not search for vape pens, doesn't even search for Google. They just search for the patent database, through the patent database and through another database called Chemical Abstracts Plus that basically just has scientific literature. They spent less than 7 minutes searching those databases, and it granted a patent over this. And so one of the results of examination is sometimes what are euphemistically called low quality patents, but these really are patents that shouldn't have been granted. And often this is because examiners just lack the time and resources to do a thorough review. They don't find that relevant prior art. They grant patents that were overbroad. And then this bargain between the inventor and the public breaks down. So they get this market power, this period of exclusivity without any public benefit. And potentially that exclusivity might even give them the rights over pre-existing technology. So that can be seen pretty clearly, I think, in the DMT vape pen case, because here's somebody with a patent now on things that already were being made and used prior to the filing of that application. And so different responses to these low quality patents, of course, there's Porta Sophia, it's like a prior art library that has prior art and also has submitted these pre-issuance submissions. Any member of the public can submit these pre-issuance submissions basically to put prior art that the examiner might not find in front of the examiner. It's also, of course, possible to challenge a patent after it is granted. And actually, more than half of patents that are challenged after they've been granted are invalidated. The former Chief Justice of the Appellate Court for the Federal Circuit looks at all patent cases, actually called the Administrative Board Patent Death Squads because of their propensity to invalidate lots of patents. So you think that might be a solution, but of course, these challenges cost hundreds of thousands of dollars, and in litigation, even millions of dollars. So this isn't something that's just available easily to just about anybody if they want to challenge a bad patent. And so even if the prior art is found, how does this affect the types of patents that are granted? So let's presume now, and we'll go through a case of where the prior art is found. How is that prior art assessed in view of what the difference is between the prior art and the invention? And so just to sort of provide some context around what is obvious and what is not obvious, we can kind of think of this as 2 sides of the equation. There's the inventive activity itself. So this is actually not Thomas Edison, but this is Joseph Swan, so kind of a competitor of Thomas Edison, who invented the light bulb just around the same time. So the inventive activity itself, and then the outcome of that activity. So here he was doing some inventive activity and invented the light bulb. And so the kind of or some ways of thinking about obvious inventions are if there's a product of just routine experimentation, if there were a finite number of solutions one was choosing between. So the inventive activity itself, in view of that, is sometimes called if it's obvious to try a particular solution. And then if the results themselves are predictable. So if it was obvious to do something, or if it was obvious the results you get of it, then the invention is obvious. Whereas something is not obvious if one doesn't have any expectation of success in doing the inventive activity. There's no suggestion or motivation even to do that activity in the first place. And the outcome of it might be surprising. So the activity itself is not obvious and the outcome of that activity is not obvious. And when one thinks about it back to what we discussed at the kind of outset, that the invention or the patent is supposed to be both an inducement and a reward. It's an inducement to invest in this inventive activity, to take part in performing activity that wouldn't happen in the ordinary course. And then also to reward the inventor for disclosing the outcome of that activity. So as Kimberly mentioned, another form of intellectual property is trade secrets. One needn't file a patent application if one discovers something that's surprising. Maybe one keeps it a trade secret, but of course, that might then not distribute that to the public, and the public wouldn't have the use of that. So the patent is seen both as the inducement to invest in this activity, to do it in the first place, and then if one gets a surprising and non-obvious result, to disclose that to the public in exchange for receiving a patent. So if we look at another patent examination, this is another sample patent. Does what's actually inventive satisfy that bargain with the public? So this patent application, this is the applied for claim, covered a composition with an entactogen and a psychedelic in the same dosage form. So basically, a psychedelic and an entactogen together in the same dosage form. And so the examiner looks at the prior art. The examiner finds some prior art. They find two references, one that had rats injected with MDMA and LSD. So that's a psychedelic and an entactogen. And they found another reference where an individual took MDMA and LSD together in a single session. So some here who maybe are familiar with drug culture or drug terms might know this as a candy flip. So here's an individual who took MDMA and LSD together. And then the applicant amends their claims and they argue in response that MDMA and LSD, well, these were actually in two separate solutions. So these weren't the same dosage form. And neither was this individual who took LSD and MDMA together. That was in separate dosage forms. And so if this is in the same single oral dosage form, which is the amended claimed invention, the examiner found that that would overcome the prior art. And this now was something that was novel and inventive. And so the patent was granted, covering an empathogen or entactogen and a psychedelic in the same single oral dosage form. So we can ask if inventiveness, if the bar is set at that level, is actually providing an incentive to lead to the types of inventions that, as the public, are ones that we're hoping to get. I'm just looking at my time. Okay, so I will, I think, end there. We'll share my slides as noted, but I just will invite others, perhaps maybe in view of what else is discussed here, to think about how we as a public can find ways to get involved in the patent system and setting what those balances are. So let me stop my share.
All right, thank you, Graham. And now we will hear from Juliet.
Okay, great. Let me share my screen. Okay, can everyone see these slides okay? Okay, awesome. So hello, everyone. My name is Juliet Meccia, and I am a patent and data analyst from Porta, Sophia, a nonprofit psychedelic prior art library and patent monitor. And our organization is so thrilled to be hosting this webinar today with Maria, Kimberly, Graham, and Simeon. So thank you all so much for joining us and sharing your knowledge. We're super appreciative. And we organized this panel in the hopes of providing a comprehensive overview of the psychedelic patent landscape from diverse perspectives. So now my colleague Jeremy and I are going to delve deeper into the world of patents and psychedelic IP. And I have some overlap with Graham, so I'll be brief in some sections. But we really want to empower everyone here with enough knowledge and tools to spot threatening patents of many varieties. And we will also show you how anyone can take action and promote good patents. Before we begin, I'd like to give everyone a brief overview of what Jeremy and I will be speaking about today. So I'm going to talk about how the explosion of the psychedelic field over the past few years is directly linked with a massive increase in psychedelic patents being filed and granted. I'm going to go into more detail about why psychedelic patents with overly broad claims are dangerous to the field, walk us through the third-party intervention process, and show everyone how psychedelic prior art that's used in these interventions and submissions can come from sources that innovators may not think of. Oops, sorry, the chat popped up for me. I just want to move that. But it is not letting me. There we go. My bad. I'm going to pass things over to Jeremy after that, and he's going to take things over and talk about how Marcus claims are strategically used in psychedelic patents and what the ramifications of these claims are. And he's also going to speak about compound derivatives, which is a trend that Porta Sophia has been tracking in patent applications. He's going to talk about search tools that can be used to return chemistry-specific prior art, and he's going to wrap things up by explaining some of the services offered by our organization, Porta Sophia. So we're all actively aware of the recent psychedelic hype bubble and how many individuals and entities are promising to make significant advances across all stages of the R&D pipeline with the ultimate goal of bringing psychedelic therapeutics to market. So we've seen the headlines, we've observed the influx of new companies and startups, we've watched the research community embrace what were once considered risky and fringe ideas, and we've seen the FDA take an increasingly interested stance in engaging with companies pursuing psychedelic medicines. But let's explore more about what's behind this boom of interest and activity. From our research at Porta Sophia over the past 7 years, we have seen a 1,200% increase in threatening psychedelic patent applications that are being filed in the US. So this indicates a huge influx of capital, which is a double-edged sword for IP in the pharmaceutical and biotech world. While more funding provides increased opportunities for innovation, it can also result in a frantic race towards monopolizing the field by obtaining as many patents as possible or obtaining patents that are comprised of overly broad claims. So a large percentage of these applications are trying to monopolize existing knowledge and practices that are in the public domain. And as we've just learned from Graham, the process of patenting intellectual property involves many steps. So in order to be granted, a patent examiner must deem that the application's claimed invention is useful, novel, and non-obvious. But due to examiner time constraints and the staggering volume of patents that are filed, patents may be granted despite the existence of relevant prior art. So this statistic I'm sharing is really staggering and indicates that there's this increasing trend of overly broad applications that threaten the public domain with the potential to truly stifle innovation in psychedelics. So let's talk about why high threat patents are considered and who should care. Basically, the implications and the consequences of granted threatening patents is worrisome for patent examiners, innovators, researchers, investors, underground practitioners, basically anyone operating in this space. So if you're an innovator in the psychedelic field, the potential of an overly broad patent application being granted could have downstream consequences on your work that you may not even realize. A patent is essentially, as we learned from Graham, a government-sanctioned monopoly on an invention or technology, and the inventor owns rights over inventions claimed in their patent. This is obviously hugely financially beneficial if you're the inventor, but a granted overly broad patent can stifle innovation by reducing the capacity of others to use aspects of the invention and increases the risk of infringement, which may be accidental. So let's say you're a researcher in the academic or private sector. You may not even be aware that aspects of your research may have been patented, and an inventor with a granted patent covering aspects would have legal standing to pursue litigation against you. Porta Sophia, our organization, operates a multi-step intervention strategy to ensure that good psychedelic patents, so ones that do not contain overly broad claims, are promoted. We start off by tracking all new United States Patent Trademark Office and World Intellectual Property Organization applications and granted patents every week, focusing on those containing to over 30 psychedelic compounds that are on our shortlist. So we triage the threat of these applications and these patents, looking through the breadth of the claims to determine the presence of any shortlisted compounds, and we search through the patent data and embodiments to determine whether the information that's provided in these sections actually covers the scope of the claims. Finally, we select high-threat, overly broad candidates for a process called third-party intervention, where we compile portfolios of existing prior art for submission to the USPTO. So what exactly is an overly broad high-threat patent application? By this, we mean applications comprised of claims that contain information already available in the public domain. So this information might be in the form of scientific journal articles, books, patent applications or granted patents, news articles, and even Reddit or web forum posts. And all these type of media basically that are publicly available are considered prior art. And third-party intervention is a process that anyone can do, and I'm going to walk us all through a case study as an example. For our case study here, I'm going to be talking about an application filed by Pharma America Holding Incorporated. And this patent application claimed an invention combining MDMA, a common psychedelic drug, with sildenafil, which is also known as Viagra. So let's use this application to demystify the third-party intervention process and also explore broad prior art search strategies. So as I mentioned before, the pillars of patentability dictate that an invention must be useful, novel, and non-obvious. And this is super important to keep in mind here as we go through this case study. Let's take a closer look at the claims that are contained here in the application of interest. So we can see right off the bat that the first claim is describing the MDMA and sildenafil combination with a specific therapeutic indication to treat erectile dysfunction. And this combination is well known in the field. Many pieces of prior art exist showing that the claimed invention is not novel and is obvious. So we deemed this application as a fantastic candidate for intervention. The USPTO created the third-party pre-issuance submission process to allow third parties to submit portfolios of relevant prior art that assist patent examiners in their deliberation. The benefit of this process is that submissions may include prior art the examiner did not come across in their own prior art search. And as Graham mentioned and I mentioned previously, the vast overwhelming number of patent applications received by the USPTO actually reduces the amount of time that an examiner has for this prior art search. So once a third-party submission has been filed, the USPTO checks the submission for compliance and, if accepted, passes the submission on to the assigned patent examiner. It's also really important to note here that this process is not used to argue against claims in the application, and any submission that contain claims will be deemed non-compliant and the USPTO will reject them. I'm going to show you an example of the preferred formatting for third-party submission in the next couple of slides here. If we head back to our Pharma America application, here are some screenshots directly from Porta Sophia's third-party submission, which we filed in 2022. The first page of the submission should contain a list of all biographical information pertaining to the application, including the applicant, serial number associated with the application, the filing date, and the title of the application. Some may also contain a confirmation number, group number, and may have an examiner assigned to them. And all of this information is readily available on the USPTO's Patent Center website for anyone to find. Next, we include a reference list that names each piece of prior art used in the submission, and we organize these prior art documents by chronological order from their appearance in the claims chart. And this is super important to give the examiner an easy overview of all prior art documents being submitted. Finally, the rest of the third-party submission document is comprised of the claims chart. And this is essentially a table containing claims from the application of interest on the left-hand side and all relevant prior art references, plus detailed quotes of their relevance on the right-hand side. So you can see here that claim 1 is copied in full into the pending claims column, and multiple prior art references plus quotes with bolded emphasized text are copied into the references column. And this format should be used for each claim in the application that prior art is being submitted for. So if we take a look here, we see 3 references for academic journal articles, which is a very commonly used type of prior art. But I also want to emphasize that there are many types of prior art that are often overlooked. So traditionally, we think of prior art as peer-reviewed journal articles, patent applications, granted patents. But really, any piece of media that's in the public domain and accessible to anyone can be considered prior art. So due to the nature and history of psychedelic drugs, locating prior art can be quite difficult. Indigenous and long-standing cultural practices using psychedelic-containing plants and fungi may not be recorded or readily accessible. As many psychedelic compounds are also scheduled, there's a long history of underground use. So websites like Arrowhead contain decades of experience reports and blog posts that are actually just as valid pieces of prior art as an academic journal article is. In our third-party submission for the MDMA and Viagra patent application, we sourced several pieces of prior art from Arrowhead, where users describe combinations of these compounds to treat sexual dysfunction. And if you're wondering, does the USPTO really view an Arrowhead experience report as a legitimate piece of prior art? The answer is yes. So in their final rejection of Pharma America's patent application, the USPTO actually cited several pieces of prior art submitted by Porta Sophia, including from Arrowhead. You can see that in the screenshot here. And this really emphasizes that by thinking outside the box, we're able to locate prior art that a patent examiner may be less likely to come across in their searches. Porta Sophia has a large online library containing thousands of pieces of psychedelic prior art, like the ones I've just shown you, making it easy for others to quickly access documents from a broad range of media. And here's a quick demo of how this prior art library works. So if you visit our website, you'll immediately be able to search for keywords or compounds that you're interested in, and you can filter results by publication date and prior art type and category. And our psychedelic prior art library is a really integral part of our mission to promote good patents and stimulate innovation. We're also constantly adding to this library, and we have a truly diverse selection of prior art, not only from journal articles and patents, but also from books that may be out of publication. We have international foreign language documents, niche websites, blogs, and more. So what exactly is the broader impact of our third-party submission strategy? Excitingly, we see Porta Sophia's impact constantly increasing, and as the patent lifecycle takes time, evidence of our hard work is continually observed. As of March 2024, we have seen 4 applicants abandon their patent application following a third-party submission from Porta Sophia. And this is significant, as Graham mentioned, the patenting process is lengthy and costly, and abandonment indicates that our submission of prior art was so robust and irrefutable that the applicant deemed pursuing their application was no longer beneficial to them. By providing USPTO patent examiners with strong submissions of prior art for patent application claims, we have seen 9 applications receive non-final rejections in which the USPTO examiner cited prior art submitted by Porta Sophia in a third-party submission. And several of these applications also received final rejections, again citing our prior art, even after the applicant amended their claims to be narrower in scope. 3 applicants have independently amended their overly broad claims following one of our third-party submissions without direction from the USPTO to do so. And this indicates that applicants and companies are increasingly aware of Porta Sophia's role as a watchdog of good patents, and also understand that the USPTO recognizes our third-party submissions. This kind of self-correction is truly an important byproduct of our workflow, as it decreases USPTO examiner workload. Porta Sophia is the only organization in the world undertaking this scope of work. And as of March 2024, 89% of all psychedelic third-party submissions have been filed by us. And this is something that we are extremely proud of. It's important to emphasize that we continually track updates on our past third-party interventions, and the patent process is not immediate, with actions sometimes taking up to 12 months. So this means that we have not even yet seen the full scope, the full impact of our work that we undertook in 2023. And maybe this presentation will inspire someone to go out and file their own third-party intervention, which would expand the scope of this important work even further. So to recap everything I've shared today, the main take-home points I hope you remember are that while the recent increase in overly broad psychedelic patent applications is concerning for everyone operating in the space, third-party interventions exist as a unique tool for anyone to take action and protect the public domain. Finding psychedelic prior art can be difficult given the very nature of these drugs, but thinking outside the box is a fruitful tactic to locate unique sources for use in these third-party interventions. And Porta Sophia has an extensive library containing thousands of pieces of such prior art. This is a resource that we provide to everyone for free. It will always be free, and we really encourage you all to use it. So thank you all for your time. I'm going to hand things over to my colleague, Jeremy, now.
Thank you, Juliet. All right, everybody see my slides?
Yes.
Okay. Cool. So my name is Jeremy Rolquin, and I'm a chemistry data and patent analyst with Porta Sophia. Today I'm going to be talking a little bit about the trends that we're seeing in the patent landscape, including the increase in applications that have to do with structural derivative claims, as well as X-ray powder diffraction analysis. So as you can see from this graph, we've seen a 1,433% increase in these types of applications from 2016 to 2022. And so next I'm going to discuss what these trends may indicate for the future of psychedelic research and patents. Some of you may be wondering, what is X-ray powder diffraction analysis? And it's basically an analytical technique used by chemists to characterize chemical polymorphs of drug compounds. And a polymorph is simply a different crystal state that can exist for a particular compound. And these different polymorphs can have vastly different stabilities and solubilities. So to put into perspective, X-ray powder diffraction analysis in reference to patents with an analogy, you can imagine a company taking regular table salt and doing X-ray powder diffraction analysis on it, and then claiming that they found a new polymorph of just regular table salt. They'd be able to patent that polymorph, and even though the salt has probably existed in that form for thousands of years, they would get exclusivity to it, and then manufacturers of table salt would then be infringing on that patent if they were to produce that specific polymorph. An example of X-ray powder diffraction analysis in the patent space is atorvastatin, which is also known as Lipitor, and it's a high blood pressure medication which was first patented by Pfizer. At one point, it accounted for over 25% of their yearly revenue. And at one point, Teva Pharmaceuticals developed a polymorph of that drug called atorvastatin calcium, and they were able to circumvent Pfizer's exclusivity of that drug. And it basically allowed a competitor into the market years before Pfizer's exclusivity had ended. Examples like these aren't confined to the sector of high blood pressure medications, and you could also see something like this playing out in the psychedelic sector as well. So a few things to keep in mind about XRPD. XRPD fingerprints or readouts can be different for the same material. This can be due to impurities or calibration of the instrument. And just like in the table salt analogy, these compounds could have existed in these forms for years, if not decades, from various sources, but the analysis of them by X-ray powder diffraction analysis is what is novel and what allows people to get the exclusivity on these compounds. So here on the left, we have an example of readout of XRPD. You can see there's two polymorphs and a hydrate of psilocybin. And this particular peak at 17.52 theta allowed Compass Pathways to patent this particular polymorph of psilocybin. And on the right, you can see that recent XRPD applications have attempted to patent distinct crystalline structures of some long-standing psychedelics, such as psilocybin and MDMA. Next, I'm going to talk a little bit about Marcouche claims in the psychedelic field. A Marcouche claim is simply a claim that lists alternative entities for which that can be selected for a patent claim. And in the psychedelic landscape, and particularly the structural derivative landscape, this refers to the structure of a psychedelic compound which has multiple points of variation on the structure to which different substituents can be added. So on the right-hand side, you can see that structure in the Marcouche claim, and that's the Marcouche core. And there's R groups on there to which substituents can be added, and the Marcouche claim gives a list of different variables that can be placed at those positions. And so a Marcouche claim can allow a patent applicant to apply for a vast number of compounds without ever specifying a particular chemical entity. So I've got two case studies here for you, the first of which is a patent application from Compass Pathways from this year entitled Modified Indoalkaloids for Therapeutic Uses. On the right, you can see a Marcouche core. In this case, it's a tryptamine. And further to the right, you can see the typical Marcouche type language that is used in these Marcouche claims. And this one patent application claim was able to apply for 101 billion different compounds in just one claim. The next example I have for you is an application from Camtech from last year entitled Tryptamine Derivatives and Their Therapeutic Uses. Again, on the right, you can see the Marcouche core, which is, again, a tryptamine in this case. And further to the left, you can see some of the typical Marcouche type language. And just from this one Marcouche claim, Camtech was able to apply for 1.1 trillion different compounds. So there's a couple issues that we're seeing with Marcouche claims, and the first of which is enablement. So enablement basically states that someone who is skilled in the art should be able to do the experimentation that was in that patent without undue experimentation. So in a lot of these chemistry patent applications, with all of these compounds listed, one represented synthetic method cannot reasonably apply to all of those different compounds. And in some cases, the function and efficacy of all these compounds are not determined by the applicant, and that would cause undue experimentation to somebody skilled in the art of chemistry. So basically, what you're trying not to do is make the person who is skilled in the art explicitly determine how to make each compound. That should all be done by the applicant. So the number and presentation of the alternative should also not detract from the comprehension of the claim language. So a lot of time recently, we've been seeing patent applications that are using somewhat confusing language, possibly to try to trick a patent examiner into not quite understanding what compounds they're claiming, and possibly giving them access to those compounds because they do not understand what they're asking. So some more issues with Marcuse claims in terms of the patent examiners. So members of the Marcuse group should be sufficiently few in number so that the examiner can look at them and assess the claim without serious burden. So examiners get roughly 29 hours for their first review of a patent application. If we go back to that the second case study that I showed you, in 29 hours for 1.1 trillion different compounds, the examiner would have roughly 25 billionths of a second per compound to search all of the literature. So it's just completely unreasonable, and these Marcuse claims consume a disproportionate amount of the examiner's time. So we have a few solutions that we can propose for these Marcuse claims. Firstly, we could shift the burden of the prediction onto the applicant, requiring them to indicate which structures are more likely to possess the claimed utility towards a specific indication. Additionally, we could impose fees for each compound within a Marcuse claim, which aligns with the current practice of charging applicants per claim in their patent application. So if you could charge a patent applicant with a Marcuse claim even 1 cent per compound claimed, if we go back again to that second case study, 1.1 trillion compounds would cost $11 billion to patent. Finally, the patent examiner could emphasize the necessity for a written description that sufficiently details that the claimed invention to establish the inventor has had it at one time in their possession. So again, to those case studies, it's very unlikely that anybody has ever had 101 billion different compounds or 1.1 trillion different compounds in their possession. So they could use that to help enforce these claims. So there are a number of existing tools currently on the market for searching for chemical entities. Reaxys, Sci-Tech, and PubChem are among the large chemical databases that facilitate drug discovery and development. And these tools also serve to locate patented chemical structures, even some of those included in the Marcuse claims that we've discussed. However, accessing these databases can be associated with substantial licensing fees, and their layout can be confusing to someone who is unskilled in the art of chemistry. Which is why Porta Sophia is currently in development of a psychedelic derivative search tool, which is a chemistry-focused resource for researching psychedelic derivatives. This tool will be accessible, free to use, and have a specific orientation towards patent research in the psychedelic space. And it is in part designed to address challenges arising from Marcuse claims within the psychedelic sector, and aims to streamline the search and analysis process in this relatively niche field. This tool will be useful for academics, researchers, patent applicants, and patent examiners alike. So here we have a prototype for a psychedelic derivative search tool, which would allow the user to identify a parent structure from a particular class of psychedelic compounds. Here we have tryptamine shown, and choose points of substitution similar to how they are listed in the claims of a patent. It'll assist the user in identifying compounds that have been named explicitly in the claims of a patent, even those from the Marcuse claims that we've discussed, to enable them to determine whether these compounds have been applied for previously. It'll list patent applications and note relevant information for the user to assess the patentability of the compounds of interest. So Porta Sophia offers a number of prior art services, the first of which is our third-party intervention service. Juliet has gone over most of the workflow for this service earlier in this presentation. Our team compiles comprehensive portfolios of prior art relevant to a filed patent application that a client can use to mitigate technology sequestration risks and prevent costly future IP disputes. Now, if we were going to file against the application anyways, we would just tell the prospective client that we already have it in our queue and that we would be doing it for free. Our landscape analysis service allows a patent applicant to avoid potential patent infringement and exhibit due diligence to their investors. and provide a full assessment of the client's freedom to operate, specifically in regards to their patent interests. Finally, we also provide patentability assessments, which is a critical step for any innovator in the psychedelic field. This process evaluates the potential for securing a patent, and it focuses on the challenges of new technologies in the psychedelic space. We use a comprehensive assessment, which involves comparing new inventions against existing prior art. So we've covered a broad spectrum today, beginning with the significant rise in derivative and XRPD patent applications. This uptick is indicative of the growing interest in advancements within the psychedelic field. We've also discussed the complexities surrounding Marcuse claims, including the challenges they present in this space and the strategies being developed to address them. We've also explored Porta Sophia's psychedelic derivative search tool, which is designed to facilitate the exploration and research of psychedelic derivatives, making the search process more accessible and manageable. And finally, we've looked at Porta Sophia's prior art services and their importance in the patentability assessment process. So in conclusion, overly broad patents are a threat to everyone currently operating in the psychedelic space, and understanding the unique psychedelic prior art is essential for R&D and IP protection. There's been a large increase in patent applications with XRPD, derivatives, and Marcuse claims, and we aim to address these through our third-party intervention efforts, our prior art library, and our psychedelic derivative search tool. And with that, I would like to thank our collaborators and supporters. And with that, I will pass it off to Simeon Schnapper.
Good evening, everybody. Hopefully my connection is stable. It's been up and down all day. I'm on the coast of Zanzibar. Share a little perspective how we look at things from the VC perspective. Yeah, I remember the first VC I met. It was quite some time ago, right around the turn of the century. And I was asked to do some diligence, and I go, what do you do? And he goes, kid, it's simple. I make the most amount of money in the shortest amount of time with the least amount of effort. And I've been ruminating on that for some time, and I think it's appropriate to comment on it as it relates to this conversation, where you put profit over people. I think in this space, it's significantly different based on the speakers here, based on what's happening in the world. So with that being said, a little about my history. I started fairly early. I was lucky enough to meet two giants in this space when I was a teenager, who were working primarily with LSD and certain modalities of therapy, and was, more or less bit by psychedelic bug, and made a decision a few decades from policy to it's come up great with Maria on Indigenous, although the term reciprocity wasn't used. That seems to be the common label, at least in the last few years. Spending a lot of time in various communities, from the Amazon to Mexico to now the last week around East Africa biologics, with a bunch of pit stops going across the Congo Basin over the next week. Obviously money, obviously the underground, which is where a lot of this existed up until, really around 5 or 6 years ago. That's where, we started to see some very strong signals that this would be a space for investment. And our thesis, in addition to, investing early and significantly great teams, was that this will be a unique space, and potentially different than your traditional biotech, as we're all kind of seeing with the news of certainly, it seems like there's news every week that's controversial, with an opportunity to optimize. So we look at patents quite closely. When you meet a company, they're all at different stages, but we usually meet really early. We like to be involved with with startups and entrepreneurs at the very beginning as they're still ideating. Sometimes it's a chemist with an idea. Sometimes it's somebody with an idea who doesn't have a chemist. Sometimes it's in a jurisdiction which is amenable to psychedelic medicines. Oftentimes it isn't. And that spans everything from actual drug development and discovery, which I would say from the VC perspective right now, and the industry is where it's most heavily weighted. Also education, education from primarily therapeutic protocols and what will be the evolution of curricula and credentials, and as certain molecules gain greater acceptance, how will those be administered? So the education, insurance, and then the other category, which isn't technically called psychedelics, but has a lot of patent law around it, or can, is everything that's virtual reality, wearables, non-invasive neuromodulation, brain-to-computer interfaces, etc. So the landscape here for the entrepreneur as well as the prospective investor is really broad. I don't think it's just the plant or just the biologic or just the synthesized chemical, although that's where the focus has been. I'm also being mindful of the time. I know we're technically 3 minutes over, but I'll go a little longer, and I hope I don't step on anybody who is off to whatever jurisdiction's happy hour. Or actually, maybe in some summation, because it is happy hour here. Patents are, I want to say they're, a requirement. Civilizations change, peoples change, borders change, but it's a system we have, and it has its benefits, and certainly, its champions as well as its detractors. I don't think we've, from the VC perspective, necessarily are trying to reinvent the wheel. We're trying to invest wisely in ethical entrepreneurs who have a deep repertoire of all the different dimensions that comes into being successful in this space, where they don't. And that's where we can help participate by introducing advisors, jumping in ourselves, socializing them within our network to other portfolio companies. This is also true of other parts of the industry. Love it or hate it, insurance is, a thing that's accepted, and it's something that people benefit from. Lastly, and maybe coming all the way to the beginning with Maria's wonderful talk, the importance of maintaining a culture throughout all this, whether it's the culture of an indigenous community that goes back millennia, or even, because there was so much mention of directly and indirectly, the underground, like Arrowhead. There was some conference we were at about a year ago. Somebody asked us, like, where do you see the next, clinicaltrials.gov? And I think I responded with, we're seeing a lot of stuff that you could, find on Arrowhead 10 years ago. So applauding the work of all things prior art to both aid and protect anyone who is proposing to file a patent. Very critical. Yeah, we're at a really incredible time for this industry. Patents will be a part of it if they're used judiciously to protect as well as accelerate, really good teams. Then I applaud them. And maybe with 5 minutes over, technically, I will say adieu, and thank you for letting me sit in. And I thought this was really exceptional. And I'm sure others will be asking for slides, but I want them all. There's definitely some new things there. Namarka stuff. Thank you all, and have a great night.
Thank you so much, Simeon. I'd like to thank you all for joining us today. We hope you've enjoyed all the insights shared by our panelists. Please visit the Porta Sophia website to learn more about how we're supporting the public domain and the psychedelic patent landscape at portasophia.org. If you have any questions, feel free to contact us or any of the panelists. You can contact us through our website, and we would be happy to connect. And thank you, everybody.